It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, geriatric care coordination, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment or progressive decline before, during, or after a hospitalization, an instance of incapacity, caregiver burnout, stress on family members due to some or all of those instances I just mentioned. As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. We take a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation, but also, and without additional cost to our active clients, they have access to our affiliated certified public accounting firm for preparation of their personal tax returns. They're invited to our client-only educational opportunities. They have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary and when appropriate, unlimited access to our elder care coordinator. That's a person who assists with whatever help our clients may need as they age, including setting tours of various facilities, arrange for help in client homes, arranging moving and downsizing, and advocating for Nugen Law clients when necessary. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or Auburn locations. You're also encouraged to see us online at www.nugenlaw, Nugenlaw, nugenlaw.com. Today, I have a member of the Nugen Law interdisciplinary team, attorney Jesslyn C. Smith, here in this studio. Jesslyn is licensed to practice law in Indiana. Has been doing so in excess of a decade, and impressively is the most recent past president of Indiana's chapter of the National Academy of Elder Law Attorneys. Welcome, Jesslyn. Great having you on.
Thank you, Bryan. I'm excited to be here today.
Great. Always a pleasure. So let's get right into it. What is an estate planning attorney and what is an elder law attorney? How do they relate? How are they different?
Well, any attorney can be an estate planning attorney, but an elder law attorney really takes a deeper dive into your situation and looking at unique issues, such as if there's incapacities, disabilities, or things like that in nature that would affect how the estate plan really needs to be put together.
Sure. Sometimes I've seen advertisements for attorneys saying, we'll get you in and out quickly. We'll throw together a trust for you. And I think of that as most definitely an estate planning attorney. They may hold themselves out as elder law, but frankly, if they're cranking out a trust or cranking out a will and providing no other services, they're really not embracing everything that an elder law attorney does. That elder law attorney is not only planning with the client to see, are we going through probate when you pass away? Are we trying to avoid probate when you're passing away? But they're also protecting assets during your lifetime, securing benefits for clients during their lifetime, and making sure that they're aware of other resources for them as they age that are out there in the community. So at Nugen Law, of course, we practice elder law. We do estate planning, but we practice elder law, and it's a much more in-depth, robust way of helping our clients and advocating for our clients, securing benefits for our clients. So most assuredly, that's as you're aging, it is important to work with an elder law attorney. But even then, elder law attorneys, this part is a little deceiving. It could be a person that's younger that is seeking services of an elder law attorney. I think of someone that's a special needs person, or someone that's had maybe an accident, TBI, traumatic brain injury. So Jesslyn, how is it that an elder law attorney would work with someone that maybe is younger than 65?
Yeah, so elder law really isn't defined by the age of the individual. It's really, is there a deficiency or disability or incapacity that the individual has, and how can we help them secure the benefits so that they can continue to live their lives and make things easier, essentially for them so that they can continue to go on. And so an elder law attorney, it really isn't meaning an age for the person. It's about what care needs they have.
Mm-hmm. Yeah, I think maybe originally, so many years ago when that phrase was kind of coined, we could have considered that a little differently, because it is much more robust. And you're regularly working with folks that are special needs, creating special needs trusts and doing those types of things for them. So while primarily as an elder law attorney you are working with a mature clientele, it isn't necessarily for someone that has to be 65 or older, or 70 years of age or older. It's more about the services that we're able to secure for them and assets we're able to protect for them as part of that representation process. And then at Nugen Law, not only are they working with you as their elder law attorney, their estate planning attorney, but what other services do they have available to them if they've contracted with you?
Absolutely. Depending on the type of service that they've contracted with us, they may have access to our elder care coordinator. And even though, again, we're using the word elder care there, it doesn't matter the age of the individual. I recently had a situation where I had a 50-year-old client that had some disabilities and everything. And even though we're using the elder care coordinator, I guess maybe our elder care coordinator is a care coordinator.
There you go.
Yep. And so he's going to help the client with coordinating the things that they need to be successful and be able to still live.
And those things could be a safety button to, if you fall, to be able to push. My gosh, he has arranged travel plans for folks. He's arranged for transportation, for food in the home, to be familiar with local activities like PACE or anything within the community, resources that may be available to them, securing medical appointments, organizing for personal service agencies to come into the home of clients and provide direct care for them. So any number of things could be secured with that elder care coordinator at Nugen Law. Jesslyn, if a client has scheduled a time with you at our office before your first meeting with them, are there things you encourage them to think about in advance of that first meeting?
Absolutely. Our intake specialist sends a form to the client to fill out, asking for some basic information. We want to know, do they have prior documents? We want to know who are their children, who's their family, who's their doctor, who prepares their taxes, who's their financial advisor, because all of those players may be important in our discussion and deciding what needs to be done for them.
I'd like to tell folks, don't worry about using legalese. Don't worry about using, a certain phrase or a term that you heard from your neighbor or read online. Just come in and talk to us about, what have you thought that you wanted to do with your estate? What goals do you want to achieve? And sometimes clients have the words for it. Sometimes they don't. They just need to be able to conceptually say to us, we've heard that you can protect money. How do I protect money? We've heard that you don't have to sell the home as you age. You don't have to sell the lake house or the farm as you age. It can be protected. How do I do that? And then also think about who are the folks that you're going to be involving yourself with to look out for you as you're aging. Who's going to make healthcare decisions on your behalf? Who may make financial decisions on your behalf? Who are those players? And sometimes it's children, sometimes it's not children, doesn't have to be. But I like people to think about that. Big concept things. They don't need to worry about the details. We'll worry about that for them. Is there information or are there documents that clients should bring with them, Jesslyn, during their initial meeting with you and ongoing meetings with you at Nugen Law?
I usually like to see a spreadsheet or, maybe just a listing of what generally they have so that they can indicate to me what it is that they do have and maybe how they want those things to go and to who. And so having just kind of a basic idea of that, even if they've got to write it down or just knowing that enough that they can communicate that with me is something key in our discussions.
I find it very helpful if the client can come in and say, I have life insurance policies and they're either term or whole, and here's the cash value, here's the death benefit value. I have an IRA or a 401k or I have a brokerage account, because each type of investment or asset that they have may result in a different way of handling that asset. So if the client can come to us knowing or generally having a knowledge about what assets they have, generally the value of those assets, it's incredibly helpful for us. And I sometimes clients are, I'll hear clients say, well, I don't have that much, or I'm not sure if I have enough to do this asset protection I've heard you talking about. Well, I do not know. I've been doing this for over 30 years, and I tell you, I don't know what a lot of money is or what a little money is, because whatever you have, there's someone else that wishes they had it, and there is no magic number where it's too much or not enough. It's unique to each person. But to be honest with you, Jesslyn, or being honest with me, as we're meeting with the client, it sincerely helps us help them. We have no opinion about how the assets are invested or if it's a lot of money or a little money. It really is just how can we help them, for sure.
Yeah, it's about their goal.
Yep.
It doesn't matter how much it is. I get it as well where clients are like, all I have is my house. But is that house important to you?
Right.
And is it important to leave it to someone?
Well, and let's not forget the value of that home. I only have as a home. Okay, and it's $250,000. That's $250,000.
Yeah.
It's a fair amount of money that they have. So now that's not to say we have clients that have significantly more wealth than that as well. But the point is that it's the amount of wealth that someone has is unique to them, and we need to know that to be able to best serve them and make recommendations to them. So, Jesslyn, in your first meeting with your clients, what is it that you're focusing on when meeting with them?
My focus is finding out what their goals are. What are they there for? What have they heard? What do they think they need? And then I focus on educating them on what options and tools we have to service those goals.
And you as their attorney, Jesslyn, their elder law estate planning attorney, what goals do you want to achieve for your clients?
My goal is to accomplish their goal. So if their goal is to, for instance, avoid probate, I'm going to discuss with them what tools we have to do that. And I'm going to educate them on the fact that, you may want to avoid probate, But probate also isn't a bad thing, as most folks tend to think that it might be, but it's not. And so I want to educate them as far as what options they have. But if their ultimate goal is to avoid probate, here are the tools that we have to do that.
Sure. There are lots of different types of instruments we discuss and prepare for our Nugen Law clients. So let's educate our listeners about some of those different instruments. First, instrument most people think of when they think about estate planning, last will and testament. Jesslyn, what is a last will and testament, and what's the purpose of a will?
Yeah, a last will and testament is a legal instrument in which you decide where you want the things that you have go when you pass away, and who's going to carry out those wishes for you. You pick who that person is that's going to make sure the assets that you have are distributed to the ones that you stated in that will.
So that person you're appointing, we call them a personal representative or executor, executrix, that's set forth within the will. And I oftentimes have people during our first meetings, just as I'm sitting down, say, all I need is a simple will, quote, a simple will, close quote. That may be the case, or they may need something else. I encourage them to allow me to speak with them, get to know them, and learn about their goals, and then allow me to make some recommendations for them to consider. Our client is always in charge. They make the final decision. But I want to make sure that it is the best informed decision for them to achieve their goals. I want and enjoy for them to use my training, for them to use your training, Jesslyn, our education and experience to reach their goals. Of course, that's what we want for them. And that if we have a robust conversation with them, or we have a 5-minute conversation with them, it doesn't cost them any more or any less. So I want to share my knowledge with them. I know, Jesslyn, you have that same desire. I have so much information to share with you. Please take advantage of it while you're here. This is the time.
Absolutely. I want to educate them. I want them to make the best informed decision about what fits their situation. It's not about what my goals are, because it's their situation, not mine, and I want them to feel like they're leaving there making the best decision.
Definitely. When a person does have a will, right, and that's all they have is a will, not all, but that is the instrument they use for their estate planning, and they pass away with assets in their name, they're required to go through the probate or estate administration process. You mentioned that a few moments ago. Please explain to our listeners what probate is. What is that?
So probate is where you simply take your last will and testament, or if you don't have one, someone goes down to the courthouse and files with the court to have an estate opened on your behalf in order to make sure the assets are distributed to the heirs.
Mm-hmm. Excellent. And that process, how long does probate or estate administration typically take?
It typically takes a year or more is what we usually see in most situations. And it can vary depending on if there's real estate involved or not that has to be sold. Is there creditors and things like that? At minimum, it does have to be open for a minimum of 3 months, but on average, we usually see about a year.
Right. Sometimes less, sometimes more. Mm-hmm. If there's litigation in it, right, it's always longer. So we should say to our listeners, at Nugen Law, we do help folks through the probate process, and we represent personal representatives through the probate process and lead them through it and make it as smooth for them as is possible. Next, let's not forget about one of my favorite estate planning tools. That's the trust. When I mention use of trusts to clients, they can become a little nervous, right? They're concerned if their estate is large enough or it's too large to merit having one. How do they manage a trust? Is it going to be expensive, etc.? So the term trust covers a very large number of instruments. Jesslyn, what is a trust?
Yeah, a trust is simply a contract with yourself that states the terms of who you want your assets to go to when you pass, and you have a little more control within that document because you can decide when and how the individuals also receive those assets.
Excellent. And so when I'm looking at a trust, there are different players in that trust. We have the settlor, the trust maker. So settlor, grantor, trust maker, all the same thing, synonymous. We have the trustee, the manager of the trust. We have beneficiaries, lifetime beneficiaries, ultimate beneficiaries. Let's start with talking about the trust maker. Who is that?
That is the client, and that is the person creating the trust or creating that contract with themselves.
Mm-hmm. Then we move on to the trustee. Who's the trustee and what's their responsibility?
The trustee is the manager, or I also like to refer to them as the key holder. They're the one who has the key to the trust, and they're the one who manages and handles the trust.
Excellent. And the trustee can be the client, correct? They can be their own trustee?
They can be their own trustee with certain types of trusts.
Sure. And then we have beneficiary, lifetime beneficiary and ultimate beneficiary. What's the distinction between those two?
Lifetime beneficiary is the person or persons that can receive the benefit while you're alive. Mm-hmm. And then the ultimate beneficiary is who receives the trust assets after you pass.
Excellent. So if we're talking about a trust being used strictly for estate planning purposes, and we're looking at something called a living trust or a revocable living trust, normally the trust maker, the client, so they're the trust maker. They contact you, Jesslyn, contact me. They have that trust prepared. They've signed the trust. Then they transfer assets into the name of the trust. And then on their own behalf, they manage that as their own trustee. And during their lifetime, they are the beneficiaries of the trust. So they're the trust maker. They're the ones that manage the assets in the trust, and they benefit from the trust. If an individual, though, has set that up and at some point they become incompetent or incapacitated, then are they able to be their own trustee at that point?
No. If there's an incapacity or a disability that occurs, there's language usually in the trust that appoints a successor trustee to make sure that the assets are managed appropriately.
Excellent. And the beneficiary, we talk about lifetime beneficiaries. Normally for, as I say, living trusts, the individual that's the client is the beneficiary of it during both instance of capacity and incapacity. But after they pass, then assets are being transferred to their children, their charities, friends, whomever they're giving assets to. It's that term of the contract which allows one to avoid probate, to avoid estate process. So talk to us, Jesslyn, about what it looks like when someone passes. How do we get the money to those beneficiaries, those ultimate beneficiaries?
So the trustee or the manager of the trust gathers all of the assets from the trust, and they look at the terms of the trust to see who you named and how much each individual is supposed to receive of the trust, and the trustee writes checks to the beneficiaries, the ultimate beneficiaries of the trust. So whoever you've named, the trustee would disperse those funds then accordingly. Now, usually they're doing that after there are certain things that are taken off of the top, such as administration expenses, or if there were funeral expenses and things like that, that comes off at the top. And then they disperse the money to the beneficiaries.
So we talked earlier in today's show about the probate process. The trust avoids that probate process. What's the length? And you referenced earlier that probate process is typically 1 year, more or less. Not hard to hit that mark at all. How long is the trust administration process by comparison?
It usually is a lot faster because the trustee has immediate access to the assets in the trust. Whereas with the probate process, you have to get appointed by the court as personal representative first before you can gain access to the assets. And there's no time frame in which we have to wait at minimum in order to start making the distributions.
Right. So conceptually, if there's strictly cash in the trust, right, somebody passes at noon at 12:01, right, we can satisfy any expenses of the deceased and distribute the money. It's that fast.
Yep.
So normally clients may call, who had the trustee of the client may call our office after mom, dad, their loved one passes and say, what am I supposed to do? I'm the trustee. What am I supposed to do? And frankly, our conversation with them, unless they want us to do it for them, is rather limited. You have access. It's like you're the president of this little corporation. You have access to all those assets in that trust. You're signing as the successor trustee, the administration trustee. You can write those checks. You can sell the real estate. You don't need to advertise in the newspaper. You don't need to tell the court what you're doing. It's really very efficient and a huge time saver. Frankly, it's confidential. You don't publish anything you don't file anything with a court, and it's a big cost saver, for sure.
Absolutely.
One of the questions that often comes up is, do I have enough money to have a trust put together? And what's your answer to that, Jesslyn?
I tell clients, it's not about how much money you have. It's about what's important to you and what your goals are. It doesn't matter to me if you've got $20,000 or if you've got millions of dollars. If your goal is to have some privacy, having maybe a little more control about how and when beneficiaries receive things, and avoiding probate, then a trust is appropriate for your situation. If you're not worried about your heirs going through probate, then maybe a last will and testament is what you need. But it's about finding out what your goals are and then identifying which tool is best for you.
Sometimes I'll hear folks say, well, I have that all. I don't need a trust because I have beneficiaries designated. I've designated beneficiary on my brokerage account, so I don't need a trust. So what are the pitfalls of relying strictly on a beneficiary designation?
Yeah, pitfalls of relying on beneficiary designations is, what if that beneficiary is later disabled and they're receiving public benefits themselves? If they inherit that money then through the beneficiary designation, they are subject to lose their benefits then that they need for their disability that they may have, whereas you can have some control over that and putting it into a tool we like to call a supplemental needs care trust or special needs trust. And with those trusts, that can protect your beneficiaries' inheritance so that they wouldn't lose it or lose their public benefits.
I think of a trust as it's like a beneficiary designation on steroids. I can say money goes to my children. In the trust, I can say, if money goes to my children. If my children have passed, it goes to my grandchildren. But my grandchildren can't get the money until they're age 25, and they can get a percentage at 25. They can get some at 30. They can get some at 35. I can control all of that. I can say that they don't get immediate access to money. If they need it for their education, they can receive it. If they need it for to go on a trip, they're an undergrad, and to go on a trip that they never would have been able to access without those funds, then the trustee can release the funds to them. So I like to think of that, the trust as a beneficiary designation, but that can do so much more than putting somebody's name on a line. For example, if you designate a grandchild as a beneficiary and the grandchild is a minor, the parent or parents will be managing that money on their behalf, and then at age 18, assuming money is left, the kids get the money at 18. You can spoil someone and very quickly by them getting money too early. And I like to see us trying to avoid that if possible. Well, we're running short on time. Thank you, Jesslyn, for joining me today and our listeners. You've provided some invaluable insight. You're a huge part of the Nugen Law team, and we sincerely appreciate having you work with us and all of our clients. I look forward to next weekend to speaking with you, our listeners, Saturday morning at 9 a.m. for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. Enjoy your weekend, everyone.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.
Podcasts by Federated Media.